Welcome to Sexual Harassment and Abusive Conduct Prevention Training. Today we're going to be talking for approximately 1 hour, and this is an interactive training session. So if you do have any questions, feel free to go ahead and type it in to the cursor and provide your email address. If I'm unable to get to all your questions during the presentation, what we're going to do is respond by way of email after the presentation. So thank you for attending, and let's get started. First, I'd like to give you a general overview as to what our discussion is going to be about today. We're talking about both discrimination and harassment, specifically on the basis of sex, gender, sexual orientation, gender identity, and expression. As you'll see on the slide, we have both state and federal law prohibiting discrimination and harassment on the following basis, some of which offer additional categories such as national origin, religion, age, mental and physical disability, medical condition, pregnancy, race, and the list goes on and on. But for the purposes of our discussion today, what we're going to do is just concentrate on the first 4 categories that I've mentioned, which is sex, gender, sexual orientation, gender identity, and expression. Towards the end of our presentation, what I'm going to do is discuss abusive conduct, workplace bullying, as some of you may call it, in the workplace, and how best to prevent that kind of behavior at work. So let's get started and talk about sexual harassment first. Sexual harassment has certainly been in the news quite a bit through the Me Too movement. But before we get talking about that, let's take a step back and let's look at sexual harassment from a historical perspective. What I mean by that is, how did it come in the national stage, okay? So let's go back to 1991, where I have Clarence Thomas and Anita Hill up here on the screen. And as you may recall, in 1991, Clarence Thomas was nominated to be on the Supreme Court of the United States. And as a nominee, he had to go through a Senate Judiciary Committee hearing. During that process, a former colleague of his, Anita Hill, was called to testify. During that nomination process and that hearing process, Anita Hill provided very descriptive details as to allegations of sexual harassment against Clarence Thomas when she had worked for him at the Department of Education and at the EEOC. As some of you may recall, this was the biggest introduction in the national stage regarding sexual harassment, where Anita Hill talked about in very graphic details some of the conversations that she had with Clarence Thomas, including views he had about pornography, him propositioning her, and of course that infamous Coke can where he asked her one day who had put pubic hair in his Coke can. So all of this unfolded on the national stage, and we as a nation were certainly introduced to sexual harassment and what kind of behavior was involved in such sexual harassment allegations. Well, as many of you know, after the hearings, Mr. Thomas was still confirmed, and he currently sits on the Supreme Court today. Fast forward to 1994, where now we have former President Bill Clinton and Paula Jones, who are embroiled in a legal lawsuit. So back in 1994, Bill Clinton was a sitting president of the United States, and Paula Jones, who is a private citizen, had sued Bill Clinton for acts that he purportedly committed when he was the governor of Arkansas. And Ms. Jones alleged in a civil lawsuit that Mr. Clinton had actually propositioned her in a hotel room when she had worked for the government of Arkansas. Specifically, he had exposed himself to her. According to Mr. Clinton, this wasn't true, and ultimately he settled out of court for approximately $750,000. Okay, And again, that lawsuit actually raised some issues that are relevant today. Specifically, can a sitting president be sued from a private capacity regarding acts that he committed as a private citizen? And the answer to that is yes. The Supreme Court of the United States actually held back in 1997 that a sitting president is not barred from civil litigation. And that particular ruling is relevant today because President Trump is actually getting sued from several litigants on a civil capacity. All right, so now what? After that particular background, what do we have very recently? A few years ago, we had the start of the Me Too movement. You'll see here, actress Alyssa Milano had basically tweeted, if you've been sexually harassed or assaulted, write Me Too and reply to this tweet. And what had happened is that there was quite a bit of response with regards to this particular invitation, and more people who are in the public eye, men and women, celebrities, politicians, people, authors, and so forth, actually had come out and shared their stories with regards to sexual harassment and sexual assault. So what does this mean for us in the past couple of years? We have seen people who have gone on marches. We have seen a lot of mobilization with regards to sexual harassment as well as sexual assault and battery. We have seen lots of publications regarding these types of stories that are personal to many men and women regarding their experiences with this topic. And we've also seen a lot of individuals, of course, who have been accused of sexual harassment in the public arena. I'm going to go through about 8 of them to just highlight just how diverse this group of people are and the kinds of responses that they've provided regarding these kinds of allegations. Okay, so at the top of the list, we have Harvey Weinstein, who was at one point extremely powerful in Hollywood. He was the head of the Weinstein Company, was a big production company in Hollywood. And dozens of women to date have actually come forward and shared stories and shared allegations regarding Mr. Harvey Weinstein, anything from actually being sexually battered and assaulted by Mr. Weinstein, all the way to being propositioned by him or being retaliated by him regarding them rebuffing his advances. Mr. Weinstein is currently facing criminal charges in the state of New York. He has basically come out and said he sincerely apologized for some of his behavior, but he's denied the accusations generally and has stated that those are basically consensual sexual relations. Okay, so we'll see how that plays out because he is facing some criminal charges. The other individual here is Kevin Spacey. Mr. Spacey, as many of you know, is a very well-known actor. And about a year and a half ago, he was accused of having relationships with a specific underage boy. I think it was about 17 years old. He has come out and basically stated that he is seeking treatment and evaluation regarding this. He's never admitted to the behavior. And ultimately, he was fired from the House of Cards, which was something that he was filming at that time. The other individual here is Asia Argento. Asia Argento actually was one of the first women who came out and accused Harvey Weinstein of sexually harassing her. Specifically, she claimed that he actually sexually assaulted and battered her. Not too long ago, about a year ago, a specific male co-star who was underage actually accused her of having sexual relations with her. And she claims that she's deeply shocked and hurt by the news, and she claims that it was absolutely false. And she denies having any sexual relationship with the accuser. So, you'll see there that their responses have been quite varied. Other folks on this list, we have Donovan McNabb, who, as you know, was a former football player. At the time of the allegations regarding sexual harassment, Mr. McNabb was working for ESPN. He was accused by colleagues, female colleagues, of propositioning them and asking them out. He denies it. He claims that he did not sexually harass anyone. Nevertheless, he was let go from his position at ESPN. Matt Lauer was the anchor and host of the Today Show for many, many years. He was highly compensated, and ultimately a female colleague of his came out, accused him of sexual harassment. NBC did an investigation, and within a matter of about 3 or 4 days, Mr. Lauer was also terminated from his position at NBC. One of the interesting facts that actually came out of the investigation is that Mr. Lauer, at his office in NBC, had a lock installed under his desk so that he could push that button and his office door would actually lock the person in there with him. So, sounds like perhaps NBC could have some culpability because there was a lock installed within their actual office. So perhaps that sped up their investigation and his termination, but we'll see. The other individual here is Trent Franks. Trent Franks is a former representative in the state of Arizona. Mr. Franks basically began to discuss inappropriate topics in the workplace with some of his female staffers. Specifically, he told some of the female interns and staffers that him and his wife were having difficulties conceiving a child. So he started to discuss their struggle with infertility. Ultimately, he propositioned one of the female staffers that worked for him if she wanted to be a surrogate from him and his wife. Obviously, that created a very uncomfortable working relationship when your boss is propositioning you to be a surrogate. He has since apologized for his behavior and has realized that the intensely personal topic might certainly make other people uncomfortable. Last couple of folks on here, I'm going to start with Russell Simmons. Russell Simmons, obviously another music mogul. He has quite a bit of diversity in terms of his portfolio and music and fashion and so forth. He has been accused by several women of sexually harassing them and also assault and battery. He has totally denied those allegations and has claimed that the relationships were consensual. But since those allegations came out, he actually has stepped down from his board in his own company. The lady on this screen is Cristina Garcia. Ms. Garcia was a representative in the state of California. She was accused of having inappropriate relationships, and specifically she was accused of actually groping a male staffer that had worked for her at one of the work events that she was at, and she has since apologized for her behavior. And last but not least, we have former Vice President Joe Biden and currently a presidential candidate. And not too long ago, there was a lot of discussion about Mr. Biden's touchy-feely, hair-sniffing type of behavior towards certain women. And these women have said, well, we don't know if it's really harassment, but he certainly had made us feel a little bit uncomfortable with the way he has behaved with, maybe a little too touchy and sniffing the hair of folks. So he has come out and he said, look, social norms are changing. I understand and I've heard what these women are saying, and he is realizing that he has to change his behavior in the way he interacts with folks, even though perhaps within him he's well-intentioned and he doesn't mean to make people uncomfortable, but he recognizes that perhaps his behavior is making people uncomfortable. So that gives you an idea of the diversity of folks, men and women, for different kinds of industries that are being affected by the Me Too movement and sexual harassment and sexual battery and all sorts of these allegations, right? So nobody is in any way insulated from these kinds of allegations, and you could see that it certainly affects all types of people. So let's take a quick step towards the global perspective in terms of sexual harassment. So the Me Too movement is not necessarily limited to just the United States. I have a picture up here of a protest that went on in South Korea where thousands of people actually went out, supported the Me Too movement, and really has brought this whole discussion to a global standard, right? Other countries outside of the United States have been going forward, having these discussions, bringing to, instituting laws to protect both men and women from sexual harassment and battery. Specifically, I wanted to highlight how the globe basically has prohibited sexual harassment explicitly in the workplace, just to kind of give you an idea as to how the United States compares to other countries, right? So you'll see this map of the world where the countries in red that are highlighted in red have no laws, no prohibition against sexual harassment in the workplace, okay? And the countries in yellow have prohibition against sexual harassment, but only with regards to protecting women. So if you're a man working in these countries that are highlighted in yellow and you've been sexually harassed at work, there's no recourse for you. There's no legal avenue for you to take because there's no protections that have been put in place. And then lastly, the countries that are in green, including the United States, and most of North and South America have protections put in place to protect both men and women from sexual harassment in the workplace. Okay? So let's shift back and talk about the United States. So the United States, where does the law prohibiting sexual harassment come from, right? Most of you guys who are watching this will have employee handbooks and company policy, corporate policies that have been put in place. And within those handbooks, you have policies in there regarding the prohibition of sexual harassment. Well, where does that policy come from? Well, that policy comes from both federal law as well as state law. For those of you watching in California, specifically the California Fair Employment and Housing Act, called the FEHA, is the California statute that prohibits discrimination, harassment, and retaliation on the basis of sex or sexual orientation. And under federal law, which is applicable to all states, federal law Title VII under the Civil Rights Act of 1964 prohibits sexual harassment as a form of discrimination of sex. Okay, that gives you a broad overview there. So federal law will see that the Equal Employment Opportunity Commission defines sexual harassment as unwelcome advances, requests for sexual favors, other verbal or physical conduct as a result with a sexual nature. Such actions constitute sexual harassment when it affects individuals' employment, it unreasonably interferes with an individual's work performance, and it creates an intimidating, hostile, or offensive workplace. With regards to California state law, the FEHA, which is the statute, prohibits discrimination and harassment based on sex and sexual orientation, including physical harassment, verbal harassment, visual harassment, or sexual favors. Okay? I have a quick question that's popped up here, and it says that what is visual harassment? So obviously physical harassment is easy to figure out, right? Physical harassment would be somebody touching or groping another individual in the workplace. Verbal harassment would be somebody who is, for instance, asking you out or telling dirty jokes in the workplace. So visual harassment, think of it this way. In today's modern age, it could be an employee who's sharing inappropriate sexually related pictures on their iPhone or their computer. It could also be an individual who's decided to put up, scantily clad individuals all over their cubicle, right? Pictures of people who are scantily clad all over their cubicle. that could cause visual harassment. So it comes in different kinds of forms, whether it's electronic, whether they're actual physical photos that you put up in your office or cubicle. So that's what sexual harassment is. Excuse me, that's what visual harassment is. All right, so everybody says they know what sexual harassment is, and people like to throw those terms around, sexual harassment, I've been sexually harassed. But what does it really mean from a legal perspective? In order for us to really try to decipher what the term means, let's go through a few hypotheticals to illustrate just how fact sensitive the inquiry is. Okay, so the first hypothetical, we see an individual, an assistant enjoys providing shoulder massages to her supervisor. So is this deemed sexual harassment? Well, gosh, there's a lot of facts that I've left out, right? For example, what if I tell you that the assistant and the supervisor are actually excited to be receiving and providing the shoulder massages? Does that then create a sexually harassing environment? Well, who's being harassed if both of them are actually consensually into it, right? So under those very specific circumstances, the answer would be no, if they're both agreeing to it and it's consensual. However, what's the bigger picture here? That kind of behavior is definitively unprofessional in the workplace, right? And what else? Relationships in the workplace can be fluid. Perhaps the supervisor one day has to reprimand the assistant because she's been coming late to work, right? So now that relationship may change, and all of a sudden the assistant may not be so happy providing the shoulder massages to her supervisor, and hence may create some kind of feeling that now she feels obligated to, or she's being forced to provide those types of shoulder massages. The other thing too is that sexual harassment isn't necessarily limited to the two individuals, for example, that are in this hypothetical. Think of it this way. What if other individuals in the workplace are walking by and viewing this kind of behavior on a daily basis? Every time at 5 o'clock, they see these two people giving and getting shoulder massages from each other. That could make third parties in the workplace uncomfortable regarding the behavior, even though it's consensual. All right, what about this scenario? We have a scenario where the delivery person is flirting with the office intern, okay? Well, again, we're gonna have to ask whether or not the behavior is unwelcomed by the office intern, okay? So we'd have to do an analysis as to, does the office intern actually enjoy having this flirtatious connection with the delivery person? That's going to have to be answered by a thorough factual analysis. The reason I put up this particular hypothetical is because some people think that sexual harassment is limited to folks that are working only in the workplace, right? But here we have a third party who's not associated with the company, who's not an employee of the company, but is in fact maybe creating a situation where your employee is in fact uncomfortable, right? So sexual harassment extends beyond those people who are actually employed with the company, but other people who are having interactions with your employees could also create a hostile work environment. Next scenario, an employee goes to the office over the weekend to view pornography on a company computer. Or first of all, this would most likely be a violation of your company policy, your electronic company policy regarding usage, right? And accessing certain websites. So that in and of itself would probably violate that kind of electronic policy. But what about sexual harassment? What if these people are in fact, doing it on their own laptop, doing it on the computer, laptop, not bothering anybody? Well, again, think of it this way. Just like the shoulder massage scenario, it could potentially affect other people, perhaps people who are walking by, people who may use that company laptop or computer at a later date and be provided with some of that visual harassment. right? So again, it's not limited just to the individual viewing the pornography, but perhaps other people seeing them do that could make for an uncomfortable situation. Last hypothetical here. What if we have a coworker asking another employee out on a date by way of text message? Well, we have in our scenario where Matt sends a text message and asks, hey, I'd love to take you out tomorrow if you're available. I was thinking dinner and a movie. And let's say the female colleague says, hey, I think you're really great. I just don't think the chemistry is right between us. And Matt responds, no worries, see you around. Thus, that in and of itself, that one time asking somebody out that you work with, all of a sudden, boom, actionable sexual harassment? Not necessarily. However, the question becomes, what happens if Matt persists? What if Matt says, you know what, maybe my coworker is just playing hard to get, and I'm going to keep asking her out until she actually goes out with me, because I think we're meant to be together, right? So if the behavior is pervasive enough, meaning it's happening all the time, and the information has been provided to the other side that I'm just not interested, then certainly if it keeps going forward, then yes, it could be deemed sexual harassment. So as you'll see through those scenarios, we really had to think about several factual details to figure out whether or not the behavior was welcome, what kind of relationship are these people having, how can it affect other third parties, and gives you an idea of how detailed you have to really delve into to figure out what sexual harassment really is, okay? But really, sexual harassment in all those scenarios fall under two very broad categories, and that is this. The first one is called quid pro quo, and it's defined as sexual demand, a demand for sexual favors, an unwanted sexual advance which conditions an employment benefit upon exchange of sexual favor. What does that mean? For example, if the supervisor says to the subordinate, you know what, I really want you to give me these shoulder massages, or I really want you to go out with me, and when you get your review in a couple of months, I'm going to go ahead and give you a great review. So that is an example of a quid pro quo scenario, assuming that the assistant is not willing to provide those kinds of sexual favors or advances. The other one is hostile work environment harassment. It's a lot broader, and that refers to unwelcome comments or conduct based on sex that is so severe or pervasive that they interfere with the employee's work performance or creates that hostile, intimidating work environment. So think about all those examples we provided, such as an individual who has wallpapered their office with scantily clad women, for instance. Visual harassment, right, could create a hostile work environment for other people who have to work there. All right, so let's go through the elements of quid pro quo, which is the first category that I mentioned. As I stated, quid pro quo, number one, you have to have unwelcome conduct, right? So the employee has to be subjected to unwelcome conduct. Secondly, the employee's reaction or required conduct has to affect the terms and conditions of employment. And thirdly, you have to have conduct that has a sexual component involved in it. Classic example that I provided you is the supervisor asking the subordinate out and conditioning that sexual favor with regards to some kind of raise, some kind of good performance evaluation. So quid pro quo is literally this for that. And then hostile work environment, the elements are that the action has to be sufficiently severe or pervasive. So for example, somebody who has groped another employee, right? That's a severe action of physical touching, or pervasive, whereas in the text message where Matt still keeps text messaging the coworker and keeps asking her out even though she's already declined his invitation. So that's pervasive. It's the constant asking, right? And of course, we have the prong of it's got to be subjectively and objectively unwelcome. The individual receiving the behavior has to find that behavior to be unwelcome as well as a reasonable person. And the behavior has to have some kind of sexual component involved in it. So these are just examples of sexual harassment. In terms of environmental harassment, it could be verbal, like we've discussed, right? It could be physical, impeding or blocking movement, actual assault, physical interference with movement, visual. It could be posters, cartoons, drawings, those kinds of visual aids. And it can include verbal, so it can be comments, it could also be just gestures or pictures or touching, leering, any of the above. Those are examples provided directly from the California statute, okay? Now, a lot of the times I get calls from clients and they say, you know, there's a relationship that started out to be consensual, hence office romance. And then all of a sudden it turned into a big problem. So there's actually statistics out there throughout the United States that there's a lot of individuals in the workplace who are engaged in consensual office romances. Here's some of the statistics that I just wanted to highlight from a recent survey. 58% of those surveyed employees have engaged in a romantic relationship with a colleague. That's over half, right? 41% of those surveyed don't know their company's policy regarding office romance. And 19% of those surveyed admitted to cheating on their partners with a coworker, and so forth. So some of the percentages are pretty high, right? So certainly office romance, at least from this particular survey, seems to be definitely happening in the workplaces across America. And so why do we care about office romances? I thought they were consensual, right? Well, guess what? Office romance can turn ugly. So what happens in a lot of situations, the relationship ends and one of the parties involved in that consensual relationship has ended it and is, you know, not interested in pursuing it, but the other person doesn't want to let it go. So imagine a scenario where the other individual who wants to continue with the relationship keeps asking the other person out in the workplace, right? That could create potentially a hostile work environment. Also, more drama involved when two people that are working together break up and one of the individuals starts dating someone else in the workplace. Now you have a third party involved in the workplace. And lastly, there could be a potential claim of favoritism by others to create some kind of liability. So I'll talk a little bit more about that. That is directly from the California Supreme Court case in 2005 called Miller versus the Department of Corrections. That involved a jail warden who was having consensual relationships with several female corrections officers at the actual jail. Okay, they were consensual. But here's what happened. Other women who were not having a consensual relationship with the jail warden filed suit claiming that his consensual relationships with the other women caused this hostile work environment because there were claims of favoritism, meaning that the jail warden imparted certain, perks to the women he was dating, but didn't impart those same perks to the other colleagues, the other female colleagues whom he wasn't dating, okay? So the California Supreme Court actually said, hey, there could be liability for a consensual relationship based on a claim of favoritism, okay? We have a quick question here, and it talks about what can companies do to protect themselves regarding consensual relationships that turn ugly. Okay, so some companies actually have instituted, well, one, policies that don't allow their employees to fraternize with each other, okay, not have these consensual relationships, especially when a supervisor and a subordinate is involved, right? As you can see, there's certainly an imbalance of power there. Other times, some companies have provided what they call love contracts. You heard me right, love contracts regarding some of these types of relationships. And what that simply means is that you are asking your employees who are having consensual relationships to come forward and advise the company that they're in fact having a consensual relationship, and that they provide that in writing, saying that no one's forcing them to have any of these, no one's forcing them to have this romantic relationship, and in fact it's consensual, so it's written down somewhere. So those are some of the techniques and some of the policies that employers have done to protect themselves regarding these kinds of claims. Last point on this is I wanted to highlight this case regarding Lyle versus Warner Brothers and NBC. In this particular case, basically you have the artistic, expression of certain work environments, butt heads with what exactly is sexual harassment. So in this specific case in 2004, assistants of the writers for the show Friends sued NBC, claiming that they were forced to sit in on meetings that the writers were having. Mind you, they were the assistants of the writers, okay? So they were not writers themselves. And they had to hear and witness the writers talking about inappropriate topics, some of which were personal to the writers, what they did over the weekend, what they did in Vegas, relationships that they were having, personal relationships that they were having. And these assistants who said that they were forced to sit in on those meetings claimed hostile work environment by having to listen to these kinds of details. Well, the Supreme Court of California actually stated that those are in fact part of their job duties and part of the creative process of the writers, and was not deemed to be sexually harassing to the assistants of the writers. And in fact, some of the topics that were discussed in those creative meetings did in fact make it into some of the episodes of Friends. Okay, but I thought that was important to note, because there's some companies out there that certainly have creative expression, as part of some of the job duties of their employees. Okay, let's quickly go through some true and false questions here. Okay, true or false? A hostile work environment harassment claim does not need to involve physical contact. Well, true, right? Because we've gone over some things, like it could be verbal, it could be visual. So you don't necessarily have to have physical contact in order for it to be actionable hostile work environment harassment. Next one, only a company can be held liable for damages resulting from sexual harassment judgment. That would be false. Each and every one of us, whether we're a manager, whether we're a non-manager, right, can be personally held liable for our own actions regarding harassment. So specifically, right, if I were to harass somebody in my workplace, I could be individually held liable for my own actions. Next one, the FEHA is the federal law prohibiting sexual harassment in the workplace. Okay, so for those of you who paid attention, the FEHA is not the federal law. The FEHA is actually the California statute prohibiting harassment and retaliation. Next one, in order to prevail, a complainant must show that the harassing conduct was unwelcome. Yes, generally speaking, that is true, right? The complainant has to show that whatever behavior was hoisted upon him or her, right, towards him or her, that they did not welcome that behavior, okay? If, in fact, the complainant welcomed that behavior, that would be a defense for the company or the accused to say, well, you know what, that was actually a consensual behavior. And last, quid pro quo harassment occurs when an employee suffers negative consequences for reporting sexual harassment, okay? That would be false. That definition is actually what you call retaliation, which is prohibited under both federal law and California state law. So retaliation is defined as it occurs when an employee suffers a negative consequence after the employee reports sexual harassment, files a complaint, assists someone else in filing a complaint, or participates in a discrimination or harassment prevention activity. So the adverse action could be like termination, demotion, denial of some kind of promotion, poor evaluation. So this protects individuals who, for instance, who are witnesses to a particular sexual harassment event, okay, and they come forward and actually provide information in an investigation. They would be protected from any kind of retaliation, as well as the actual individuals who have come forward themselves, who've claimed that they were sexually harassed. So that is protected both under state and federal law. Other things I'd like to highlight is that we have same-sex harassment is where a man sexually harasses other men or women sexually harass other women. That is still prohibited under both federal and state law. Sexual orientation of the individual is not necessarily relevant, because think about it this way, right? Let's say I put up a lot of inappropriate artwork, right? Pictures of scantily clad people all over my office. It doesn't, my orientation is irrelevant to the analysis of whether or not I've created a hostile work environment for the people that work around me. Same thing with sexual desire. And again, we got to look at whether or not there's some sexual component with regards to the behavior. So now let's talk a little bit about other forms of harassment, which I touched upon earlier in the presentation, which is going to include gender harassment, gender identity harassment, gender expression, which all falls in the same actual umbrella as the FEHA, which is the state statute. Okay, so here we have protections for the right to appear or dress consistently with one's gender identity or gender expression. It also requires employers to use the employee's preferred gender, name, or pronoun. And it protects applicants as well as independent contractors and interns who are working in your workplace. Okay? So what am I talking about here? Let's do a review as to what these terms mean and how it means for your workplace, right? So we have under the FEHA that prohibits the company from treating individuals differently based on their sex, their perceived sex, their gender identity, their status as a transgender, or an individual who is transitioning or is transitioned. Okay? So these are the definitions of gender expression and gender identity. It's going to be a lot, but I'll explain it a little bit more simply at the end. So let's read through these definitions. Gender expression is a person's gender-related appearance or behavior, whether or not stereotypically associated with a person's assigned sex at birth. Gender identity is defined as each person's internal understanding of their gender, which may include male, female, a combination of male and female, neither male or female, or a gender different from the person's assigned sex at birth or transgender. Okay? So actually, before I go forward from the next slide, think of it this way. Gender identity is how I view myself as a woman, right? I identify myself as a woman, and the expression of that is how I outwardly want to show the world my own identity. So meaning the expression is the way I speak, the way I wear my hair, the clothes I'm wearing, the makeup I'm wearing, the jewelry I'm wearing. So those are things that show or express my actual gender identity. Okay? So those are very simplified terms. Then we have transgender and transitioning. It's a general term that refers to a person whose gender may be different from the gender assigned to that individual at birth. A transgender person may or may not have a gender expression that is different from the social expectations of assigned sex at birth. Okay, so one of the most famous public transgenders who have transitioned is Bruce Jenner, who has transitioned to Caitlyn Jenner, right? So we'll see that, how does that impact you in the workplace? Okay, well, what has happened more and more is that individuals in the workplace who have transitioned, for instance, want to use the bathroom of their choice, right? So I have received calls from folks where they say, Michelle, we have a situation where we have an individual who started out as male, identified as male, and now has transitioned to female and now wants to use the ladies' restroom. However, the women in our office are not comfortable with having that individual share the same restroom as they have, okay? So under that kind of scenario, the state law is pretty clear on it, okay? Basically that the uncomfortableness of the many in the office doesn't trump the rights of the individual from using the bathroom of his or her choice, right? So hence we have these protections under the law to protect individuals, right, from who have transitioned or who is expressing their gender in a certain way to basically be respected in the workplace, okay? So that gives you an idea of how these kinds of topics impact the workplace. So generally speaking, how can sexual harassment or gender discrimination or gender identity issues arise? It could be a combination of different things. It could be women versus men, men versus men, men versus women, and so forth. You could have different numerical combinations where one employee is accusing several employees of harassment or discrimination, or several employees accusing just one individual. So those are the kinds of numerical combinations. And who can be liable for the damages? We've already touched on this, but I just wanted to highlight the fact that obviously the company could be potentially liable for such damages for sexual harassment or discrimination, right? If a manager or supervisor acted inappropriately or failed to act, or the company should have known or had known of actual misconduct. And again, anybody like a supervisor, a coworker, anybody could be in fact deemed liable for their own inappropriate harassment or discrimination. Okay? So the remedies for harassment, if somebody were to sue in court, the remedies would be actual damages, any kind of lost wages or lost benefits. General damages, which could be known as emotional distress damages. Punitive damages is just another layer of award that a jury could provide to a complainant who is successful in their lawsuit to basically, further punish the defendants. And lastly, a complainant, if he or she is successful in suing the defendants, could be entitled to attorney fees. So those are the general remedies of harassment. Okay. Now, in the last portion of our discussion, I want to go over workplace bullying or abusive conduct in the workplace. Okay? This is not specific to any kind of gender or any kind of sexual harassment. Workplace bullying, specifically abusive conduct, is much more broad. Okay? It is defined as conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Okay? It's a lot of words there. So what does that really mean? Well, it talks about infliction of verbal abuse, the use of inappropriate remarks, insults, verbal or physical conduct that a reasonable person would find threatening, intimidating, humiliating, sabotaging, or undermining the person's work performance. Okay, those are examples of abusive conduct in the workplace. Okay, and just like the two types of sexual harassment we've talked about, there's not necessarily a single act that, boom, obviously, is the only kind of abusive conduct, right? But if you have an act that is very severe or an act that is pervasive, similarly, right, especially if it's severe, pervasive, it certainly can be a single instance of abusive conduct. Now, just so that you guys have an understanding, abusive conduct or workplace bullying isn't necessarily specific to a gender or a certain category. And in fact, workplace bullying in and of itself is not actionable under California law. However, and this is where the big however is, oftentimes workplace bullying may be tied to a protected category, and hence it becomes actionable under the law. So what I mean by that is workplace bullying, right? The boss who's a jerk, right, that's not necessarily actionable. However, if the behavior, abusive behavior, is tied into or because of a specific category, such as, race or national origin or age, right? That behavior could in fact be actionable if it implicates protected categories such as what we've discussed, right? Pregnancy, race, gender, sexual orientation, age, disability, medical condition, those kinds of things. So it is in our best interest to obviously protect ourselves from, one, participating in any kind of abusive conduct, right? And two, from us being abused at work. So it's twofold. So let's talk a little bit about that. In order for us to all prevent workplace bullying, which by the way could potentially lead to unfortunately, harassment and violence in the workplace, which we all have a vested interest in actually preventing. What we have to do is we have to improve communications between management and employees. So if you're a manager watching this, you have a duty to obviously treat your employees with respect, and vice versa. If you're a non-manager watching this, you have the duty to actually also treat your colleagues as well as your managers with respect. Okay? We have to have an increased awareness by both managers and supervisors of warning signs of workplace bullying and violence. But that goes for non-managers as well. We all have an invested interest of actually reporting behavior that could be potentially abusive or potentially violent in the workplace. Okay? The company then has the obligation to respond appropriately to whatever is being reported, whether it's to provide, counseling to managers, whether it's to discipline, the employee who's actually acting inappropriately, right? And to monitor or to respond to whatever that behavior is, and to ensure that the behavior that's being reported or behavior that's being observed that's threatening or inappropriate or abusive is properly responded to, whether that's through some kind of disciplinary procedures or the person is in fact, written up or demoted or whatever the appropriate actual response would be, okay? So like I mentioned, it's in our interest to make sure we keep our eyes out, for these kinds of early signs of potential workplace violence or abusive conduct. So what do I mean by this? Obviously, if you have an employee who is verbally threatening other people in the workplace, or is engaging in intimidating behavior, or having bizarre thoughts, paranoid behavior in the workplace, and you're seeing that, or that person is sharing it with you, right? Perhaps it's obsessions or some kind of, behavior or thoughts that are not, tied to reality. Those are the kinds of behaviors we want to look out for. We also have certain things that may be a warning sign, right? If the employee is suffering from perhaps serious stress in their own personal life and it's affecting their behavior at work, right? Or it's creating a decline in their work performance, right? Those are the things that we want to keep an eye out for each other to make sure that we get that employee some help. Perhaps that employee needs some kind of counseling outside of work. Perhaps that employee needs some time away from work to get the help that they need, whether it's substance abuse or stress or whatever that may be. So all of us have the responsibility, okay, because we could all be potentially alleged bully or harasser, okay? So the takeaway from this is this. Our responsibility is we have to pay attention and receive the message being sent and respect the boundary being set, and we cannot retaliate or ignore. Let me just walk that back really quick so that you guys really have an understanding as to what I'm talking about. If, for instance, I have somebody who comes up to me and says, Michelle, I don't know if you realize, but every time you talk to me, you like to rub my back. Okay? I have the responsibility of what? Paying attention and receiving that message that's being conveyed to me, right? Then I have to respect the boundary that that individual is setting. So that person is saying, hey, you're not making me comfortable by rubbing my back. You may not realize what that is, okay? So I have to respect the boundary that that person is setting. And the last piece is, I can't get upset and then start retaliating against the person who's conveyed that message to me, right? I can't start cutting that person's hours, or I can't start, ignoring them as I see them in the office, right? I have the responsibility to not retaliate or ignore, okay? The flip side of that is, what if I, Michelle, feel like I'm being bullied or harassed? I have the responsibility to communicate my boundaries to that person, whether directly or indirectly. So either I say to the person, hey, listen, I don't know if you realize this, but you're doing this behavior and it's making me uncomfortable. If that is too much for me to do, guess what? I got to get help from other, avenues through the company, whether it's human resources, whether it's another manager, right? Whether it's a member of the executive committee, whatever it is, you got to look at other avenues to make the company aware if you're not able to do it directly, okay? So these are just examples where you can go. Your own supervisor, any member of management, or a designated human resources person, okay? So with that in mind, those are the two types of responsibilities each and every one of us hold, okay? The employer, what's their responsibility? The employer's responsibility is, number one, they have to have a policy, right, regarding harassment, retaliation, discrimination, and hopefully your company has that in place through their employee handbook or some other written down policy, okay? The other responsibility the company has, and the company is fulfilling by you actually watching this video, is that they have to provide training to managers as well as non-managers as to harassment and workplace bullying and discrimination prevention, right? And the last piece is, if any one of you, right, complain about any of these behaviors, whether it's harassment, retaliation, or bullying, right, the company has the duty to investigate and respond to the allegations being made. So that's the employer responsibility in a nutshell. So if you have any other questions, please, again, like I've stated, feel free to go ahead and email me, and I'll do my best to respond after this presentation by way of email. But otherwise, thank you very much for listening and participating.